Hi everybody, welcome here. Thanks to IDEX for organizing this and facilitating the event. We'll be talking with Arvind Narrain uh, regarding 377 efforts that Arvind and his team are doing. So, welcome Arvind. Please give us some background and what are the further steps that you'll be taking. If you can explain that.
Sure. Yeah, I've kind of titled, I thought of how to phrase this, and I titled the talk as Look, the Struggle for Equality of LGBT Citizens in India. And if you were to begin the story somewhere, we have to begin the story a long way back in 1860 when the British framed the law, which basically criminalizes what it calls carnal intercourse against the order of nature with any man, woman, or animal. And if you get back to even the why the law was framed, Lord Macaulay, in his comments on the draft penal code, refers to an odious class of offences about which as little as possible should be said. So even in the framing of the IPC, the British didn't want to quite communicate what the problem with the law was or what they were actually seeking to criminalize. But I think behind the language of odious class of offences is really the criminalization of homosexual expression. That's what we could possibly infer from the language of the law itself. And if you were to tell the story of the struggle against this particular law, there are many ways of telling that story. I'm just going to try one way of telling you the story, which is tell you the story through four cases uh, and four characters who, in some ways, search for freedom. And among the four characters, the first character would be, in fact, the first reported case of prosecution slash persecution under Section 377, which is a case in 1885 of a transgender person called Khairati. Khairati, as far as the story goes, as the judicial record shows, was a Hijra person who was basically dancing ornamentated in a public place in her village. And the British saw the fact that she was dancing. The police saw the fact that she was dancing. They inferred from the fact that she's looks like a man, but she's acting like a woman, that she must be accustomed to committing offences under 377. So they arrest her. They send her for medical examination. During the course of medical examination, it is revealed that she has an anus which is flared like a trumpet. That's what the finding of the case is. That's where the judges describe it, and the fact that there's evidence of syphilis in that particular area. Based on this, the judge, who ironically in this case called Justice Straight, I mean, we can get more ironical than that. Justice Straight in this case basically finds that there's no evidence of the fact that she's committed an offense at a particular time, at a particular place, and so he acquits her. But I think it's really very important because the point we're making under 377 again and again is really not the question of acquittal, but it's the question of what we would call persecution. Because the point to pay attention to, which I think holds relevance even till today, is not the fact that Khairati was acquitted, but the fact that she was subjected to the indignity of medical examination, the fact that based on the way she looked, she was arrested, and the fact that she's subjected to police harassment and violence. And that's really the core, in some senses, the core of the central issue which we face under 377 till today. It links up, of course, to 2013, where the judge makes the point that the uh, less than 100 reported cases of prosecution under 377. And our point is, sure, that may be so, but the point we're really interested in is persecution. The point we're really interested in the violence which is committed against people under the shadow of this law. And that's the story which Khairati really tells us. And I guess the other story which Khairati tells us in some ways is that she is among the first recorded victims of this particular law. And the fact that the law, in its first use, was actually against a transgender person. So in a sense, I mean, if you're talking about the LGBT community, the T is actually the first person prosecuted or persecuted under this particular law. And this is in 1885. The second the case I want to tell you about, is in 1935, is the prosecution of one person called Naushirwan in a place called Sindh. And the story goes like this. Naushirwan is a Parsi man running a restaurant. Then he had this guy called Ratan Singh, who's a young fellow, aged around 18, who comes to have tea or coffee in that restaurant. Then, this is the way the judges describe it. Then Ratan Singh leaves the restaurant at some point in time. Then Nashirwan follows him, goes after him, follows him up to the pair. And we can imagine that there must have been some kind of exchange of glances, some kind of eye contact which happened. And as would happen maybe in San Francisco today, the two of them decide to go up to Nashirwan's room. Right? And they go to that room and they're doing what need not necessarily concern us, but it does become the matter of the law's concern because there's a policeman who's actually peeping through the keyhole. And policeman sees what is happening. He arrests the two guys, marches them off to the police station. And the judge describes what actually happens in that particular room. According to the description of the case, Ratan Singh was seated on Naushirwan's organ, and Naushirwan spent himself before the act could go beyond a stage of lascivious consummation. That's the way the judge describes it. So anyway, the point is that they are arrested, and Ratan Singh is made to pose as a complainant against Naushirwan in this particular case. And the judge in his judgment reserves a particular ire for Ratan Singh, where he describes him as what he calls a despicable specimen of humanity. He refers to him as animal-like behavior. Then he says the hind part of the lad is used to sexual intercourse. That's the language the judge uses in this particular case, which tells you about the kind of violence which must have been done to these two guys under that particular statute. And I guess the other point which one can think about is, what is the world which Naushirwan and Ratan Singh were trying to conjure into being in a time, as it were, before time? That is, the judge prefers to see what was between them as an act of carnal intercourse. But we can infer that what could have been between them could have been an act of intimacy as well. We could infer that in some ways that room, Naushirwan's room, might have been a space where, in some ways, they questioned the heterosexism of the wider or the outer world, as it were. Right? And in some ways, they're trying to conjure into being a world where their expression of intimacy, love, affection for each other has a certain space that is in a time before time, as it were. And of course, we are now looking at these two cases from the perspective of 2013, and I think we see them in some ways as Naushirwan and Ratan Singh and Khairati in some ways as unwitting frontiersmen in the struggle against 377. Right? And if we think back historically, I'd say these three characters are really embodiments of a struggle which was way before its time. And there were people who were putting forward a view, putting forward a certain kind of a perspective in a time before these issues could even be talked about. And that's in a colonial context, right? And if we think of post-independence, the point really is that 1950 we have the coming into being of the Indian Constitution, we have the right to equality, the right to liberty, the right to expression, but really it makes no difference as far as the operation of this particular law is concerned. Because the language that judges continue to use till as recently as 2009 is animal-like, is despicable, and is abhorrent. That's the language the judges use to describe the series of acts which are criminalized under 377. And of course, the first time, it's really a remarkable moment in 2009 when, for example, you think of the language of carnal intercourse. The language of carnal intercourse in 2009 with the judgment of the Delhi High Court changes to the language of love and intimacy. And that's a profound and a remarkable shift as far as Indian law itself is concerned, where the judgment of Justice Shah and Justice Muralidhar basically makes the point. They put it very, very movingly. They say that your sexuality is something which travels with you wherever you go. And they say that it's not for the state to choose one's partner, but for the partners to choose themselves. So really there's a shift from understanding what is under 377 as an act of carnal intercourse against the order of nature, to understanding it as an act of intimacy, an act of love between two individuals, and recognizing the fact that the state has no business in criminalizing this particular act. And the judges go on from that to really, in some ways, developing Indian law, Indian jurisprudence on a range of issues really. On the language of privacy, for example, we've always had Indian law which has looked at the act of privacy as your right to be free from surveillance. And that's been the extent to which Indian law has gone, Your right to privacy is your right to be free from unauthorized surveillance, as it were. But what the judges do in this particular case is they extend the language of privacy to the realm of sexuality. And they make the point that your right to make intimate decisions about your life is a part of your right to privacy. Right? They derive it in some senses from the US law context, from the South African law context, where be it Roe versus Wade or be it Griswold versus Assenstad, they make the point that in some ways, when you when you make decisions about your intimate life, those are decisions which are part of your right to privacy. And they link up privacy in some ways to the concept of dignity. And that's a very powerful connecting link they make. Because again, if you think about dignity, in the Indian context, dignity has traditionally been applied to contexts of, for example, the question of untouchability. That's a powerful illustration of where dignity comes in. When you're criminalized, when you're dealt with by mainstream society as a second-class citizen, that's seen as a violation of right to dignity. And in this case, they apply that to the context of the LGBT community. And that's a powerful kind of a shift that the judges make in thinking about this particular issue. So in some ways, they develop the right to equality, they develop the right to privacy, they develop the right to dignity as far as LGBT citizens are concerned. And that itself is a profound and really remarkable shift. But I think where they take it one level above is they actually connect it to the meaning, the profound meaning of the heart of what the Indian Constitution means. And that's a shift which takes it to a different level altogether. They make the point that that when you look at the Indian Constitution, the heart of the Indian Constitution is the idea of inclusiveness. And when they say the idea of inclusiveness, they link it up to, once again, the speech in the Constituent Assembly by Jawaharlal Nehru, where he makes the point that in his when he's moving the objectives resolution, which defines what the preamble of the Indian Constitution is, he makes the point that words are magic things often enough, but sometimes the magic of words cannot communicate the intensity of a nation's passion. And when he says that, he's referring to the spirit of inclusiveness, which is the heart of the Indian Constitution. So the judges take that particular idea and they say that, if we say we're not discriminating against LGBT persons, it's not because we believe that a minority needs to be treated equally alone. That's not the only point. We're saying it because we believe that tolerance is at the heart of the Indian constitutional tradition. And that's, once again, a profound shift where you're saying that you're not talking about minority rights, but actually you're talking about what it means to be a part of the Indian constitutional framework. And that's a shift which the judges articulate. The second major reason why they take it in a deeper level is when they reference the ideas of Dr. Ambedkar, who's once again the founder of the Indian Constitution, and they refer to the idea of constitutional morality. They derive that from Dr. Ambedkar. And I think about Dr. Ambedkar's work. Dr. Ambedkar is, of course, an advocate of the rights of the Dalit community, which is the untouchable community in the Indian context. And in his opinion, democracy in India could never be a majoritarian democracy. Because in a graded, hierarchical and divided society like India, if democracy meant majority opinion prevails at all points in time, then what happens to the minority like the Dalit community? They have no rights whatsoever in this country. So in his opinion, the majority opinion is always controlled by the principles of the constitution. So morality, be it a public morality, be it public opinion, cannot be a way in which you determine, to which you hold hostage the rights of the minority. The minority rights will always have to be seen within the framework of the constitutional morality, and majorities cannot hold minorities to ransom. That's really the understanding of Dr. Ambedkar. And the judges use this once again to say that, as far as we're concerned, you cannot discriminate against the LGBT community because that goes against the very profound understanding of what it means to be a citizen in the Indian context. Because in a graded, hierarchical and divided society like India, the judiciary has to play the role of a counter-majoritarian institution. That is, democracy in India is not a majoritarian democracy, it's a constitutional democracy. So, this is what the judges come up with in 2009. So, in many ways, the 2009 judgment is some people, some of our colleagues refer to it as the Quran of the LGBT movement because they feel that it really anchors rights in a very deep way within histories and traditions of the Indian Constitution. You're not just making an argument for minority rights, making a wide argument, right? And I just one more point I want to make on this. One thing we've always been used to is, even in people who are supportive broadly of LGBT rights, they'll make the point that, well, actually, we don't mind supporting you guys. What you do in your bedroom is, end of the day, your business. And what the judges do here is they take the discourse beyond the question of what you do in your bedroom is your business, right? They make the point Your sexuality is something which travels with you wherever you go. So they're making the point that the sexual acts which might be performed actually linked up to a context of personhood, linked up to a context of intimacy, linked up to the context of who you are as a person, right? And so they take the argument one step further, as it were. So I would argue that in some ways, I mean, even in 2000, if you look at the decriminalization of homosexuality in Britain in 1967, the argument the Wolfenden Committee made was really, they said that there's an area of private immorality which is not the law's business. And the judges have been very justified in saying, okay, there's an area of private immorality which is not the law's business. You can do what you want in your bedroom, behave as bizarrely as you want. But the judges said, no, that's not the path we're treading down. The path we're going down is to say that the sexual acts in some ways are linked up to context of personhood and intimacy, and that's what we want to protect. We want to protect your right to personhood in the deepest possible sense. That's why we thought the 2009 judgment was a obviously very, very remarkable judgment. But of course, the 2009 judgment, as all of you know, didn't last beyond 2014 because 2013, when we had the judgment in Suresh Kumar Kaushal's case. And maybe I'll just describe to you a little bit of how we got from 2009 to 2013 so you get a sense of that particular struggle as well. There's always a debate about whether law leads social change or law follows social change. And I think we'd really argue that the 2009 judgment, in a sense, was the law leading social change. Of course, the things which contributed to the 2009 judgment, like, for example, pride marches which are happening in the country. To give you one illustration, the judges once asked the council, one of the council, your lordship, this happens in the West, it doesn't happen in India. And the judges were like, but council, what are you saying? The pride marches happen in Delhi, Bombay, Bangalore. And so obviously what happens outside influences the judges. But then the judges were remarkable because they took that and took it to another level altogether. And that's the remarkable thing of what you can do with law. That's what the judges did this time with law, as it were. And post that, of course, I mean, Indian society was not yet, in some senses, ready for this dramatic and radical judgment, as it were. And the best illustration of that was within 7 days of the judgment coming, the first appeal against the judgment was filed by this chap called Suresh Kumar Kaushal, who is an astrologer, and Mukesh Kumar Kaushal, who is a psychologist, right? And if we thought that was the end of the story, that was followed by 14 other appeals filed by Hindu, Muslim, and Christian religious groups. They range from the National Churches Council, Apostolic Churches Alliance, Muslim Munnetra Kazhagam, to Baba Ramdev, to the Manu Krantikari Manuvadi Party, to Delhi Child Rights Commission. Range of, in some senses, if you saw the TV shows at the time, for the first time we'll see Hindu, Muslim, and Christian all together on the same panel, as it were. It's like, wow, everybody's together. So we said, okay, fine, it's a terrible situation to be in. How do you counter this? Because 15 appeals filed against you communicates a really terrible picture. I mean, what do you do? What do judges do? They feel that public opinion is against this particular issue. So how do you take it forward, So the idea we came up with was, in terms of consultation with a range of groups, was see if we can file specific interventions to support both NAS Foundation, who are the original petitioners in this case, and Voices Against 377, who is a coalition of child rights, women's rights, and LGBT groups, who are also interveners in the Delhi High Court. So we were part of groups which ended up filing interventions on behalf of 14 mental health professionals, who basically made the case that homosexuality is not a disorder; it's a natural variant of human sexuality, and your right to intimate life is a part of your right to life itself. That is, your right to human happiness includes your right to intimacy, as it were. And these were very well-respected psychiatrists from National Institute of Mental Health and Sciences in Bangalore and a range of psychiatrists around the country. Then there was another intervention filed by 16 teachers led by Nivedita Menon and others, who made the point that as teachers and as we know people who are lesbian, gay, bisexual, transgender, we have students who are lesbian, gay, bisexual, transgender, and the way we see it, we see this issue as a part of a wider human rights framework. We've been a part of workers' struggles, we've been part of a range of struggles, and this is part of the work, this is part of a human rights framework in the broader sense, as it were. There's also an intervention filed by 11 law professors led by Ratna Kapoor, who made a similar point, saying that, as law professors, we believe that this law really needs to go. Then there's an intervention filed by Sham Benegal, who is a filmmaker and a public intellectual, who made the point that, as a public spirited person, I feel this law is offensive to constitutional values and constitutional morals, as it were. Then we also had an intervention filed by 19 parents of LGBT persons, and parents were from around the country. They were from Delhi, they were from Bombay, they were from Calcutta, they were from Hyderabad, Bangalore, Kerala, uh, uh, places in West Bengal, and places around the country really. And these 19 parents, they made the point that when comes to 377, there's nobody who knows the impact of 377 better than we as parents of LGBT persons. When we're at home, we suffer the fear that our children could be arrested at any moment in time when they're outside. We feel that 377 affects our right to enjoy our family life. And we feel that 377 is a profound offense as far as our family values are concerned. Right? And so they kind of turn the discourse around, as it were. And I just want to make this point also to illustrate the fact that, we were talking about this many times, that we feel that 377 is really a struggle against the law. But it's also a social struggle, it's a political struggle, it's a cultural struggle, it's a struggle against a certain mindset as well. It's a process of public education in some ways, And 2009 judgment took forward the process of public education. And in some ways, the parents' intervention, we're thinking about it. I was thinking about it, that we would not have had 19 parents intervening in 2009. We have 19 parents intervening in 2011 because in some ways of the 2009 judgment. So the law in some sense enables parents to come forward and be supportive, as it were. And the parents in turn took the discussion, as I said, beyond the courts of law. If you had watched the Barka Dutt show, which is a well-known Indian TV host, and there's one show she did on which she did on 377, in which there's a very moving image of these three mothers sitting with the three in saris, obviously with bindis, looking very very traditional, as it were, with the three kids sitting next to them, and they were saying the most radical things. They're saying 377 affects family values. They're saying how can you criminalize our children and stuff on those lines. So I was just thinking that in some ways, when LGBT activists speak, you reach a certain constituency. But when mothers and family members speak, you reach a certain wider constituency. So in a sense, the debate really went out in many ways through, I think, in particular, the parents intervention. And okay, and then we had the hearings before the Justice Singhvi and Justice Mukhopadhyay, and during the hearings, I think we realized once again. All this talk about carnal intercourse vis-a-vis right to love and intimacy, it came together as far as 2011 were concerned during the course of the hearings, because the judges were not interested in love and intimacy. They were saying, "Tell me what is carnal intercourse against the order of nature." They were only interested in what is the meaning of the phrase against the order of nature, and what is the meaning of carnal intercourse against the order of nature. So I guess in some ways we knew that the judges are not empathetic, but also I think there's such a widespread change around, as it were, that nobody believed it's going to go badly. Apart from some of the lawyers who worked on the case, everybody was like, you guys are crazy. It's going to go well. What can the judges do? Public opinion is with us. There's nothing which can go against you, as it were. And we went with that particular feeling. And the day of judgment on December 13th, when Justice Singhvi pronounced the particular judgment, I think it was a sense of shock as far as the entire community was concerned. And in some ways, as activists, we were kind of prepared for it. We said, if it goes negatively, how do we respond? So we had thought a little bit about what would be the ramifications of a negative judgment. And in our thinking, of course, it was the worst possible judgment one could give. And I'll describe to you a little bit about why it was, as Vikram Seth put it. He put it very beautifully. As activists, of course, our first response was to call it a black day for human rights, which is the most imaginative thing we could think of as activists at that moment in time. But then Vikram Seth put it as a bad day for law and love. And I thought that's a really beautiful way of putting it. And I really thought a lot more about why did he describe it as a bad day for law and love. And I came up with a couple of reasons why it's a bad day for law and love. It's a bad day for love, quite obviously, because you've shifted once again. This wonderful movement of Indian law from carnal intercourse against the order of nature to the right to love, which is the heart of the Naz judgment, is now shifted back again. We're back again to the language of carnal intercourse against the order of nature. Again, within the terms of the law, there is no hospitable space for the ideas of love and intimacy. And that's what the 2013 judgment really did. And that's why, in no uncertain terms, one would describe it as a bad day for love. But I think equally important is why is it a bad day for law? And that's maybe the reason which is little less well known, as it were. Because if you read the judgment closely, you'll realize that it's a bad day for law because at the most fundamental level, if you think, give me one second. Yeah, if you think at the most basic level, if you think that the idea of law is it's a reasoned decision, the idea of law is that you provide reasons why you arrive at a certain decision which you might arrive at. If you look at the judgment, it's devoid of reasoning. If you look at the logic of the law, the tests in Article 14, for example, the right to equality, there'll be two tests. You'll be able to demonstrate the fact that you're making an intelligible differential between two groups, and you should be able to demonstrate the fact that the intelligible differential linked to an objective. In this case, of course, the intelligible differential will be between carnal intercourse within the order of nature and carnal intercourse against the order of nature. And if you read the judgment, the judges will tell you that we think there's a distinction between carnal intercourse against the order of nature and carnal intercourse within the order of nature. And read the paragraph a little further on, they'll go on to say that it's not possible to list out the acts which come within the framework of carnal intercourse within the order of nature. And you'll wonder that, if you yourself are saying you can't say what are the acts which come within carnal intercourse within the order of nature, how is there an intelligible differential? That's a failure. And I think it's a profound failure. And the second test, which is that, okay, you made a distinction between carnal intercourse within the order of nature and carnal intercourse against the order of nature. What is the objective to which it is linked? You ask the question, what is the objective to which it is linked? The judges don't respond to that question. There's nothing in the judgment which tells you what is the objective of making this distinction. So in that sense, it's a failure of law at its most profound, at most basic, not profound, most basic level, right? And look at the argumentation on the right to privacy or the right to dignity. They'll list out all the case law, which tells you what the right to privacy encompasses, what the right to dignity encompasses. They will not apply that to the argumentation on 377 and tell you why 377 doesn't violate your right to privacy or your right to dignity. And that's like a failure of law at its really most basic level. But I think even beyond the failure of law at its most basic level, what is disturbing is the fact of what it does as far as constitutional principles are concerned. If you take two core constitutional principles, one is that human rights, fundamental rights are universal. The fact that there's no numerical bar for you to access your fundamental rights. The judges go against on that line of thinking, because they make the point that the LGBT community is a minuscule minority and hence is not entitled to challenge the constitutional validity of Section 377 of the IPC. And in our viewpoint, there's nowhere in the Constitution is it laid down that a minuscule minority does not have the right to challenge a law. And the Constitution is built on the premise that you protect the rights of all persons, regardless of how minuscule they might be, even within a minority of one, as the case may be. And that's the law laid down by the Supreme Court. So they literally go against the thinking of the Indian Supreme Court itself. And the second reason why they fail in a big way is because they make the point that let Parliament decide this particular matter. And again, people say that maybe it's okay, maybe Parliament should decide this matter. But again, that's not the scheme of the Indian Constitution. Because the Indian Constitution, as I mentioned before, recognizes the fact that if you are a minority who's a despised minority, then the only recourse you will have is really the recourse to the courts of law. And so the judiciary cannot abdicate its constitutional responsibility to protect the rights of minuscule minorities or minorities as the case may be. And so that's a failure once again in a deeper sense of what law means. I think, but beyond that is what one of our senior counsel, Mr. Shamdevan, indicated, is really in some sense a failure of sensibility. right? And that's the deepest, in some sense, the failure which you see as far as the judgment is concerned. But the judges, in some sense, fail to appreciate the what are the constitutional questions really before them, right? And again, if you think about it, what is the responsibility of a judge? What should a judge do when he's thinking about uh, issues which are before him? And if you think back again to the framing of the Indian Constitution and the Constituent Assembly debates, there's a speech by Jawaharlal Nehru in the what is referred to when India gains independence, which is the famous Tryst with Destiny speech, where he refers to Gandhi and he says the ambition of the greatest man of this generation was to wipe every tear from every eye. He says that that is the high watermark we set ourselves. Set ourselves. We might not get there, but that is really our objective. And if you put it that way, then the responsibility of high constitutional functionaries, including judges, is to be responsive to tears and suffering which are before them. And so in this case, how did Justice Singhvi, Justice Mukhopadhyay respond to the stories or the narratives which are before them? I just want to read out to you briefly two affidavits which were filed before them and which were read out by two of the senior counsel, actually, read out by both Mr. Ashok Desai and Mr. Shamdewan. One was an affidavit of a transgender person called Kokila, who was subjected to brutal rape and torture in a police station in Bangalore. I read out to you just a small part of what she had to say, and which was read out before the judges. What Kokila testified to in affidavit, she said, I suffered severe injuries on my hands, palms, buttocks, shoulder, and legs. The police also burned my nipples and chapti, which is the vaginal portion of the hijra, with the burning coir rope. One policeman of the rank of SI positioned his rifle on my chapti and threatened to shoot me. He also kept pushing the rifle butt and lathi into the chapti and kept saying, do you have a vagina? Can this go inside? While other policemen were laughing. This was done with the specific purpose of insulting me by insisting that I, as a transsexual woman, was not a real woman, as I was not born with a vagina. The other affidavit was an affidavit of Vijayalakshmi Roy Chowdhury, who was the mother of a gay man read out by senior counsel Ashok Desai. She says, my child is living with the agony and disrespect of being penalized at any point of time under an unjust law. It stopped him from coming out for long. Even after he came out, he always felt insulted since he can't live his life equally celebrated and accepted by the law and the society. The thought that Anis could, for no fault of his own, be harassed by the state makes 377 totally unacceptable for any otherwise law-abiding, just, and self-respecting citizen. So really, the only point I want to make is that as far as the way we saw it, there were tears and suffering aplenty in front of the judges. The judges chose to disregard this in terms of the judgment which they came to, which was described by, once again, one of our senior counsel, Mr. Shamdewan, as a particularly savage judgment in terms of its failure of judicial empathy, which is like a quality which 2009 showed in profound measure. In 2013, they failed completely to even empathize with what were the questions or the issues really before them. So the judgment they came to, in some ways, would be, I think you'd see it really as among maybe the three worst decisions of the Indian Supreme Court. The previous decision, which was as bad, and which once again is important to mention because what it triggered was really the Mathura judgment, which is referred to as the Mathura case. So Mathura was a 16-year-old tribal girl who was raped by policemen within a police station at 9 o'clock at night. And then she filed the case. The Bombay High Court convicted the two policemen, and the Supreme Court acquitted the policemen. Supreme Court acquitted the policemen on the grounds that there were no injuries on Mathura's body. There were no injuries on her body. It indicates that she must have gone willingly of own volition and had sex with these two policemen. And this is the Supreme Court of India. And what it did post that is it triggered in some sense, the modern women's movement. It emerged as the struggle against violence, and that's really the birth, in some sense, of the Indian women's movement, which is Mathura, which is a very, very important movement. The other judgment which you can compare this particular judgment to is really the emergency judgment, which is 1975, where the Indian Supreme Court basically held that if the executive declares an emergency, you have no right to move for your right to life, petition for your right to life under habeas corpus under Article 21. They suspended the right to life in 1975. And again, you see this as a profound failure of the Indian Constitution. So in some ways, our argument is, as far as this judgment is concerned, in many ways, if you take the percentage of the population, which is say 7 to 10%, it will be 70 to 80 million people. You're talking about a range of people who really criminalize under this particular law, right? So it's as bad in the implications as the other two judgments one was referring to. So we've said how bad the judgment is. We've said how good the previous 2009 judgment was. So I guess the final question, which I'll address and leave it open to questions, is where does one go from here? And I think the story, just to bring it up to date, is post the judgment, we had the appeal, we had the review petition, which was filed by all the parties which I described till now. And the review petitions were also had narratives, once again, affidavits of the harm suffered by people post the judgment in the last 1 month, as it were, in terms of harm as far as in terms of increased violence as far as public spaces is concerned, increased level of problems as far as self-esteem, as far as psychiatrist testimonies are concerned, increased problems as far as acceptance in families and in workspaces due to this particular judgment. And the review bench dismissed the review petitions with a one-line order saying that we see no reason to disturb the order of the Supreme Court in Suresh Kumar Kaushal. And post that, the framework of the Constitution is you have something called, you can file something called a curative petition, which can be filed in cases of what they call irremediable injustice, and matters which in some ways shock the judicial conscience. So we file the curative petition, and often what the Supreme Court does when you file a curative petition is they dismiss it in chambers, without giving you a hearing. And the curative petition goes before the 3 senior judges of the Supreme Court, plus the 2 review bench judges, as it were. And here we had a tiny sliver of hope opening out, as it were, because what has happened is the judges have decided to grant an oral hearing as far as the curative petition is concerned. So when the court reopens in July, the curative petitions will come up for hearing, and let us see how it goes. And again, to describe a little bit of the last date when the open court hearing was granted, most of the senior counsel, as far as the Indian Supreme Court were concerned, were actually on the side of saying that the law should go. We had Harish Salve, Mukul Rohtgi, Shyam Devan, Ashok Desai, a range of senior counsel there, making the argument that in some ways that this is a blot on the history of the Indian Supreme Court, saying this is something which is a matter of institutional self-correction, and we have to take action on this matter now, as it were. And one hopes that this language has some kind of impact, and we hope that the Supreme Court will be able to deliver on this point. And that's where the legalities of the thing lie, right? But I think, as I already indicated, I think it's partly legal, it's also social, it's also cultural. And I think the way we see it is what the 2013 judgment has done is it's politicized a whole range of people saying that, this law is unconscionable and really needs to go. So in some senses, it also created almost a range of new generation of activists who are saying that we can't take this judgment has to go. Range of protests around this particular issue. We had a global day of rage just after the judgment, which I think cities around the world participated in, including San Francisco, as well as a number of cities within the Indian context. And I just want to narrate, maybe once again, to indicate how, in some senses, a certain global imagination had worked as well. As about one of our colleagues in Delhi, the way he put it, he spoke about. He said, when we're protesting this judgment in Delhi here, the people protesting this judgment in cities around the country, he mentioned the name of the city, and there'd be a yell from the crowd, as it were. He'd say Moradabad, or he'd say Delhi, Bombay, Bangalore, Calcutta, San Francisco, and people would kind of indicate that they would feel that the fact that you're not alone or isolated as far as the case is concerned. The fact that there's a kind of global concern around this issue was very powerfully communicated. And one of our colleagues, he actually narrated a poem from here. Poem by Langston Hughes, which goes in Hindi, not in English, but in Hindi. It goes, "What happens to dream deferred? Does it dry up like a raisin in the sun? Does it run like stinking meat, or does it explode?" And his submission was really this. He said, what we're going to do through this is we're going to ensure that this dream explodes. That was his entire thinking, right? And that's what we see around us in terms of, I feel in many ways, you see politicization on a wider scale than ever before, to the extent that a mainstream political party like the Congress Party, which in a million years had never expected to take a position on this issue, should come out openly supportive of the LGBT rights issue. So has the Aam Aadmi Party, so has the CPIM, so has the Janata Dal secular in the Karnataka context. A range of political parties are taking a position on this, and that's never happened before. So once again, we see the fact that in many ways, the discourse has really taken a different life of its own. And so let's see where that particular struggle goes, as it were. And one last point, maybe to mention, and then I'll wrap up now, is in the middle of this entire doom and gloom around this entire judgment, as far as the law is concerned, we had this really remarkable judgment by the Supreme Court on transgender rights. And once again, it's two judges of the Indian Supreme Court, and they came up with this most progressive thinking what transgender rights in the Indian context could mean. They made 2 points. They made the point that you have the right to self-identify in the gender of your choice. So it could be male to female, it could be female to male, and surgery is not an essential requirement for you to identify in the gender of your choice. They also made the point that you could also identify as a third gender person. So they gave you a range of options, literally. They said you can either be third gender, you can be F to M, or you can be M to F. And they put it within the framework of the constitutional framework and principles. But they made the point, your right to freedom of expression includes your right to attire, your right to dress, your right to be who you are. It's linked up to a sense of autonomy in its broader sense of the word. Right? So in a sense, we've had a terrible judgment, but really a magnificent judgment after that. So it's like in some ways been a roller coaster. You've been gone down and suddenly gone up again. And let's see where we go from here. So I think that's what we do.
So the 2009 judgment kind of supported the LGBT community based on the main three constitutional acts. Act number 14, 15, and 21. 14 is the right to equality before law. 15 is the non-discrimination based on religion, race, sex, and caste. And 21 is the right to protection of life and personal liberty. So that is one point. Second point, which most of the time the courts talk about, is using 377 against the people like pedophiles, especially against the that they do against the young boys. So that was one point. But in 2012, they came up with the act called as POCSO, the protection of children from sexual offences. So that is kind of a strong point that we have going forward, right? And the third point that you just mentioned about the acceptance of the transgender rights. So considering all these 3 points, how does the future look in terms of strengthening the case?
Yeah, once again, our point has always been that we don't think of the LGBT and the T issues separately, as it were, right? Because we think of the transgender judgment, it's a remarkable judgment in every aspect. The only thing it doesn't give you is it basically implies that transgender people shouldn't have any sex. That's the one limitation, as it were. So if you take the logical implication of the transgender judgment's right to personhood forward, it is an implicit critique of the Kaushal judgment. The judges, because the two-judge bench, they can't really comment on another two-judge bench decision. So they say we're not going to comment, but in effect, they end up making the point that the 2013 judgment gets its facts wrong. They say that in terms of the entire question of the Kairati judgment which I narrated, is something which the transgender judgment talks about. It says that, there is a history of prosecution of transgender people under 377, and though we can't comment upon it, that's clearly a part of the entire story. So, once again, we hope that the transgender judgment is something which the Supreme Court will, in the curative petition, will take seriously and look at the fact that there are certain contradictions which really need to be resolved. So I think a lot hinges on the way the judges respond in the curative petition on this particular question.
Anybody have any questions?
Just to clarify, are there 2 judges on the Supreme Court?
Yeah, the Indian Supreme Court has 28 judges.
28.
And they sit in benches of 2 on matters of substantial constitutional importance. A bench of 5 judges could be constituted. And in fact, one of the prayers in the curative petition would be this: that this matter should be heard by bench of 5 judges. It should be heard by constitutional bench because it's a matter of high constitutional importance and it should be decided by 5 judge bench, not by 2 judge bench. As it were.
And are they all appointed or any of them elected?
Yeah, the language of the constitutional provision is that the president appoints the judges in consultation with the Chief Justice. And the Supreme Court has interpreted the word consultation to mean effective consultation. What in effect they've said is the Chief Justice, along with 2 senior judges, will appoint the judges of the Supreme Court. So the Indian Supreme Court actually appoints itself.
I'm sorry I came in late. My name is Ron.
Yeah.
I don't know if you've answered this question. How is this going to be approached? What will be the arguments for giving equality to gay people? What will be your basis of those arguments?
Yeah, in some senses we talked about this, that in the colonial era, there's no way in which you could make an argument for the right to equality of LGBT persons. Post the coming into being of the Indian Constitution, the argument will make for the rights of the LGBT community will be on the basis of your right to privacy, your right to dignity, and your right to equality and non-discrimination in the Indian Constitution. When you say privacy, you'll say privacy includes the right to autonomy and to make decisions about intimate life, including about who you might choose to have a relationship with. When you say equality, you'll say it's non-discrimination grounds of sexual orientation and gender identity. And when you say dignity, you'll say that when you criminalize an aspect of people's existence, which is an integral part of who they are, then that's a violation of your right to dignity. So that would be the argument.
But in many ways, people are looking at this. Here you have a bunch of sick, depraved people who are demanding equality for their deprivation. And the people are looking at it as if to say, well, in many ways, by giving this to them, we will be giving rights to criminal people. Is anything going to be done to sort of discuss this and disprove it?
Yeah, that's why I referred a little while ago to the judgment of the Delhi High Court in 2009 was a very, very important corrective to this notion of sick, deprived people, as it were. Because the way the Delhi High Court put it is that inclusiveness is the heart of the Indian Constitution. And inclusiveness means that you have a space for diversity, including diversity of LGBT persons. So in a sense, the argumentation is that we're not talking about sick or depraved or depraved people.
But that's
we're
in
really
their minds.
no, we're not. I'm talking about the Delhi High Court.
Yeah.
The way the Delhi High Court has put it, we're talking about the right to love. We're talking about your right to form intimate attachments with those who might choose to. Right? They put it with another framework also. They've displaced the attention from the idea of the act of carnal intercourse and sick and depraved and linked to child sexual abuse and a range of things.
Yeah.
To saying it's actually about your right to form intimate attachments. It's actually about your right to personhood. It's actually about your right to expression. And these ideas are at the heart of the Indian Constitution, and that is why we will protect this. That's the language.
Was there any scientific argument presented? Psychological arguments?
Yeah. Once again, we referred to this a little while ago.
I'm sorry
if
I'm making you go over it again.
Which is, in the Supreme Court, there's an intervention by 14 mental health professionals, led by Dr. Shekhar Sheshadri from National Institute of Mental Health and Sciences, who made the point that as far as the ICD classification system is concerned, as far as the DSM classification system is concerned, homosexuality is not a disorder anymore. It's a natural variant of human sexuality, and therefore, criminalizing something which is an integral part of who people are is not something which has any constitutional or any basis whatsoever.
Especially seeing that most of it, the people who are against it, they're against it for religious reasons.
Yeah.
Faith-based.
That's once again an argument which the Delhi High Court in particular addressed, which is why we go back to the Delhi High Court judgment, where they made the point that, religious leaders could have many opinions. But as far as we're concerned, we don't go with the opinions of what religious leaders think. We go with the opinion of what the Indian Constitution says. And that's the distinction they make. Public morality cannot be a basis to trump the rights which are guaranteed to you under the Indian Constitution.
Okay.
So legally speaking, how can a court admit the cases filed by the religious organizations? Because sex is a personal matter, whereas religion is totally different matter. So on what basis does the court accept these cases?
Yeah, no, I mean that was a good point because we felt in some ways that the appeals which were filed, we felt they should have been dismissed in limine. We said that, I mean, why are these appeals even being tolerated or even being accepted? Because, I mean, these are guys who are not there before the Delhi High Court. It's a little, I think, similar to the US Supreme Court decision where on locus standi question, they should have been dismissed at the first stage.
Yeah.
But it wasn't. It wasn't dismissed because the judges felt, once again, I think the thinking which the judges had is in some ways they feel that the custodians of the thinking of vast majority of Indians. They feel that maybe people have different opinions on this point. Maybe we need to listen to a range of opinions before we come to this case. And religion has to be heard. That is the opinion. That's the opinion the Supreme Court had. The voices need to be heard.
It's interesting because in Hinduism especially, there is nothing that is anti-homosexual whatsoever. On the contrary, even in the religious things, there are amazing stories of Vishnu and Shiva. Vishnu taking on the form of Mohini and having sex with Shiva, and Ayyappa was born. I mean, already you have a guy with two dads. There are so many things there but nothing there that says it's forbidden. As a matter of fact, there's a lot of talk on the third sex it's like because one of the things that I kept on hearing them sort of saying was that homosexuality was brought in from colonial British with the Muslim invasion, but in fact it wasn't. It was homophobia.
I have a few questions, and if I get a call, I have to take it. I apologize. What can we do at this point to influence the judges? Like, is there something that can be done from here to help? And also, when I visited India after this judgment happened, to be really honest, there wasn't much in the media, and there was not much talk about even like public about it. Although my family, most of them know, nobody even remotely brought it up. They're okay with me as long as it's hush hush. So, is there anything we can do from here that can provide help in some ways, whether it's financial, whether it's exposure? We did what we did for a limited time, and then it's over and done with for us in the way that, bad decision, but my life goes on. So is there anything we can do to influence the judge's decision? I mean, everything is, apply pressure from
There's definitely something we can do here, and I'll share that. But Arvind, if you have anything you'd like to mention first.
Sure.
So with a partnership with IDEX, International Development Exchange Committee, and all these guys, they've established themselves as an international grant maker for us, and our goal is to raise $10,000 that could be tax deductible. That is tax deductible for permanent individual donors, but to raise that money so that it then gets sent to organizations in India that are doing grassroots work to influence and change the hearts and minds of people there. And I would say right now, I don't know how much we've raised to date, maybe at least 1,000, if not a little bit more, but we've brought envelopes here, and it's through this partnership with IDEX that they're going to be doing all the vetting of the organizations that receive the funding. They'll make sure they follow all the specific reporting requirements so the funds are used appropriately. But it's a real opportunity, I think, to contribute.
Is this online also?
Yeah, so that's the link, idex.org/donate no going back.
Yeah. And we brought envelopes too for checks and use cash for anonymous donations.
Yeah, what I was thinking is I can put it on my Facebook and make my friends say, hey guys, let's do this. And then everybody who's my friend can say, yeah, I'll share it.
And then just make sure you know that it's that for you. There's a section on this site where you have to put in their blank field, no going back, or like they won't necessarily know because it's a more generic site that it's the funds are directed for this particular use. But and I would suggest you grab some envelopes too for everyone. That would be great. I mean, the commitment we made to IDEX is, that 10,000 mark, then they would send the money. It might be worth renegotiating that, but at least for now, we haven't done a real big push. And so Arvind coming was an opportunity to really spread the word with you guys.
Do we have like the mailing list for DSCT people? Maybe we could spread it out so that it's not just San Francisco.
Yeah, I mean, I think there's definitely an opportunity, and honestly, we need some volunteers. So we have a small fundraising team, and if you're interested in all, it'd be great to connect with us and efforts. Thanks.
No, maybe just think a little bit more about this. How can people help? And I mean, I'm trying to think. I mean, how did even this entire discussion on LGBT issues begin in the Indian context? And I think my earliest memories, in some sense, were thinking back to people who had been to the US and come back in some ways. People like Chandra and others who, I think Trikone was a name at that time for sure. I mean, right? Salga was a name which we knew about, kind of thing. I mean, I'd heard of very vaguely, but I mean, in some ways, I mean, through that thing, obviously things developed. I mean, those conversations, dialogues, whatever it is, things developed in the Indian context. So now it's a fairly vibrant and strong movement within the context of India itself. And how did that grow itself, right? You think about that. And I think one has to say that the role of funding has been fairly central to the development of this, right? The HIV/AIDS interventions. I mean, they had a certain role in maybe thinking of it purely within the HIV/AIDS public health perspective, but I think people have used that in diverse and many ways. Communities have formed and organized under the banner of HIV and taken it in very, very different directions, as it were. And that's till today, the largest network, I think, emerges out of the HIV/AIDS funding, as it were. And also another grouping, it emerges from maybe a more political framework or thinking. And that comes from, by and large, more of a feminist perspective, and the entire groups like Labia, which come from that line of thinking, as it were. And I think internationally, groups like HEWAS have been hugely supportive, the Dutch funding organization of LGBT issues, when they were not very popular. In fact, I remember right from the beginning, they've been very supportive of the entire issue. And now what you see is, I think, funders are clearly on their way out, and that seems to be the line of thinking generally across the board. So in that sense, I think in a broader sense, I'm not speaking of a specific organization, in a broader sense, I think it would be great to build those lines of solidarity, where the connections can be built within groups, who you think might be doing good work in the Indian context, to groups who want to support from here. And how one builds those links and connections might be something one can
Who is
think
working
a little
against
bit more.
us? Who is working against us? Do we know that?
These are all the religious organizations.
I mentioned 15 groups actually, Hindu, Muslim, and Christian religious groups who have been working in terms of as far as the supporting the law is concerned, and who is working against us in the biggest way today is actually the BJP. That's the most important, the most powerful source of opposition you have is the BJP, because they've come out very clearly, the one political party with no ambiguity, that they're supporting the Supreme Court judgment, and they might be the next government in power. So I think who is working against you might very well be the government of India, which is not the case now. Might be the Union of India, and that could make things a lot more difficult in the years to come. So I think that the call for solidarity will be higher. The need for solidarity might actually be.
So these judges have a lot of pressure on them, coming from.
Yeah, and that's the I guess in some senses the frustrating part, because it was an ideal scenario for them not to have gone down this path. We had the Union of India, the Government Council, was making the point in court that Section 377 is an example of sexual imperialism, making the point that we support the Delhi High Court judgment, the reasoned, well-argued judgment, we support the judgment. In spite of what the Union of India says, in no unambiguous terms, they chose to give this particular judgment, right? And they, in some senses, if you're being completely dispassionate about the issue, you'll say, okay, fine, great, here's a judge who's not responsible to public pressure. The public pressure was on him, the government pressure was on him, and yet They went against the grain, as it were. So the only hope, of course, is that even if the BJP is in power, you want the court to play the role of a counter-majoritarian institution. That is, so what if the BJP is in power? So what if the Union of India is against LGBT rights? The court can still strike down the law. And that's the hope we would still have.
So,
I'm sorry, go ahead.
no, actually, I want to be respectful of our host's time. We asked to be here from 5 to 6. So, maybe we can take this conversation and continue it informally in other avenues. But I just want to thank Arvind for being here and educating us. And maybe we can end on that hopeful note that, come July when you are discussing your curative petition, that it goes well. And I think here, as a part of Trikone and the No Going Back group, we'd love to continue to support you. I think here our best efforts are to donate so that we can financially support the grassroots efforts that are happening in India. But I do agree that we need to continue to collaborate and be there in solidarity for the groups in India. So thank you so much.
I just had one last question. One of my friends wanted to ask this question. The carnal intercourse does not apply for a women-to-women sexual intercourse, right? So does that mean the women-to-women sexual intercourse have all kind of liberty?
No, it's once again, it's a
Which would be a good thing if at all that is
No,
there.
it's a good question. It's a good question because technically you're right. I mean, as far as carnal intercourse against the order of nature is concerned, it says penetration is sufficient to constitute the offense, which means that women will not come within the framework. But then technicality and the use of the law are very, very different things. Because the 2009 judgment narrates this case of these two women who were runaway couple as it were, because they want run away to get married. They just run away together. And the family of one filed a kidnapping case against the younger woman, right? And the two were both arrested, produced before the magistrate. And before the magistrate, the argument which was made is that these women are lesbians. That's one of the arguments of the family, right? And it should not matter. You're right. Technically, it shouldn't matter. So what are the lesbians? They can't commit an offense under 377. But the judge sends the woman back to her natal family, making the observation there is an allegation of an offense under 377. So the argument really is there's a presumption of committing an offense under this law. And that presumption extends in the Kairati case of transgender persons, as far as this case is concerned, to lesbians, and extends for the gay men is concerned. So the extends to a range of people really. That's why this law is such a profoundly dangerous law, and why it needs to go.
Yeah, thanks.
That's okay. We can do it.
So what are your
Let's
plans
continue.
next? Since I know you've got some friends that you
No,
want to meet up in there.
I'm open to meeting up. I'm fine. You can just hang out wherever you guys sit.
We can go on.
Sure.
Yeah.
All right. Thanks a lot, Arvind.
Thank you. It was very
Thank you, everybody.
So where would we go with such a large group?
Depending on who all is available, and I think you also invited some people, right, Arvind? Do
Yeah.
you already have a set location?